Thanks for joining us again on Welcome to America, an immigration story in part 3 of Maria's story. If you missed parts 1 and 2, you want to go to our channel and watch those first so that you can get the most out of this segment. In segment 1, Andres tells you about Maria and her journey to America. In segment 2, we discuss the problems and challenges she'll face while trying to start a new life in the United States. While you're there, be sure to like this video and subscribe to our channel so that you don't miss out on some really great stories and information. Who knows? You might discover the solution to your own immigration problem, and we may be saying to you, welcome to America. Okay, first an update on where we're at with Maria's story. Maria lived in Guatemala with her abusive husband, who is a U.S. citizen. She fled to America with her youngest child, leaving her older child with cerebral palsy behind with her grandmother. She had crossed the border and made her way into New York. We talked about the problems she would face and some of the things to do and avoid while she's in the United States. Now, I know this is Andres' favorite part of these segments. The solutions segment, this is where we get to hear from an immigration attorney, immigration advocate, author, and television personality, Andres Mejer, about how to solve your immigration problems. Andres, I know you're passionate about helping people solve immigration problems, so let's get started. How are you today?
Thank you. I'm so looking forward to explaining what Maria's progress is going to look like, what her options are, and I'm excited to explain that to everybody. Hopefully help a few people along the way.
We're excited too. I love how in-depth you go in these meetings. Okay, so Andres, last time we talked about Maria's problem being somewhat unique because she was living outside of the U.S. with her husband, who was a U.S. citizen. She had originally claimed asylum, but you said that may not be the best solution for her. Tell me what you think is her best option here.
So remember, we talked about asylum and Vawa. So she's going to be put into removal. So what happens? She comes, she presents herself at the border. Remember, she's an adult with a minor child, right? So she's going to be interviewed. They're going to have what's called the credible fear interview. She will likely be found credible for two reasons. One, because her story is compelling. But secondly, remember, her husband's a U.S. citizen and she has 2 U.S. citizen children. So it is sufficiently unusual that she will likely be released relatively quickly, put on a bus or plane or something towards New York or towards New Jersey, where her aunt lives. Now, but she is going to be in removal. So she is going to have to present herself to court because she's telling the officer, hey, I'm going to New Jersey. The court should be in New Jersey. Mistakes happen. So they give her what's called a notice to appear. That's the charging document that begins the removal process. Now, when I look at it, I will know where she needs to go. So she's going to have an A number. It starts with the letter A and it's 9 digits. And it's on every document, including the notice to appear. I could go online or call the 1-800 number to find out when she has a court appearance. Why is that important? Because the courts are completely and totally disorganized right now. It is a disaster. So the complaint might say Newark, or it might say Texas, or it might say New York. Now, if it says anything other than New Jersey, we're going to have to communicate with that court and advise them that she lives in New Jersey. That's called a motion to change venue. So that happens a lot. It shouldn't. When she comes in saying, hey, here's where I'm going and here's my address, and she's released to that state, the closest court should be the one. But again, we're seeing lots of mistakes. That's not always what happens. So if it's not New Jersey, there needs to be what's called the motion to change venue to go to New Jersey. Let's put that issue aside for the moment. Again, why is that relevant? Well, if she's in New Jersey, she has to go to court in Texas. That's difficult to get to. She might not be able to get there. Remember, doesn't have employment authorization yet, may not have a job. I mean, if she has a court a year from now, it's one thing. If she has a court in 1 month, she just got there. She may not even know where she lives. She may not have $5 yet to even buy, diapers for her kids. How she's going to get to Texas or Arizona or Florida or California, wherever she was apprehended at the border.
Just again, part 1 and part 2, Mr. Mejer went into what she may qualify for and the different options. So I want to ask a couple questions around her scenario. Again, tune into those episodes to hear more about her scenario so you can hear how I'm about to compare and contrast how this would affect somebody with a slightly different situation. So even though she was living outside of the U.S., Maria still may qualify for VAWA. That's great. But what would be the difference, if any, if she were living in the U.S. but did not have legal status?
Okay, good question. If she was in the United States, so let's say she got here, whether she got here legally through a visa or her husband filed for her to come, or she entered here illegally, married a U.S. citizen, and has the same situation. So point is, she didn't have to make this long trek from Guatemala to the U.S. and present herself at the border because she was already here. However, she got there. How is that different? Well, she wouldn't be filing for asylum. That's number one. Because she'd be in the country likely more than 1 year. She would likely not qualify for asylum. So her option would be VAWA only, number one. Number two, she likely wouldn't be in removal. So that means she wouldn't have to go to court. So the process would be easier. Remember, VAWA is a subset or a very similar to a family-based application. In a family-based application, here it's her husband, you need to first document that the relationship is legitimate, that they married for the right reasons, not just to get immigration benefit. And secondly, that her change of status, where she goes from either an immigrant overstay or an illegal entry to a lawful permanent resident. VAWA has the same criteria, but adds that she suffered extreme cruelty. Now, if she's in removal, she can't file both components at the same time. In a family-based application, you're filing Form I-130, and then you're filing Form I-45. Now, there's a lot of other forms. It's not just two. But those are the two big ones. Document the relationship is the I-130, and then the change of status is the I-45, because VAWA allows her to file inside the United States, even though she might have entered without inspection. That is not the case in a family-based application. So I've just confused everybody. Let me try to back that up a little bit. When someone files for you, a relative, parent, spouse, or child, again, you got to document that the relationship is legitimate. The second is your change of status. Now, that could be either inside the U.S. or outside. If you're inside, well, you don't need a waiver, generally speaking, and you're going to get employment authorization. If it's outside, you might have to wait for a visa. You might have to travel out. No, not might. You will have to travel outside the United States. And sometimes you need a waiver before you file. So the process is longer. It becomes more expensive, and you don't get employment authorization while that happens. In a VAWA scenario, that almost never happens. You always will be able to change your status in the United States. You may not get employment authorization right away, only because you might not yet be able to file for that second component. And that's what happens when someone's in removal. You can't file for both stages at the same time because you're dealing with two different agencies. So USCIS will adjudicate the document, the relationship part, but they can't approve. When I say adjudicate, I mean approve or deny. So the USCIS can't approve or deny a green card because you're in removal. That goes to the judge. So if she's inside the United States, she's when this happens, right? Because in both scenarios, she's now inside the United States, but in one, she presents herself at the border and say, hey, I'm afraid to go back. And in the other one, the question you just asked me, she's already here. So we're not filing for asylum. We're only talking about VAWA. And in the VAWA situation, if she's already here, she's going to get employment authorization. She's going to be able to work right away. She's going to be able, her process might still take 2 or 3 years, but there's no judge involvement. There's no trial. Now, if she's in removal, so the scenario where we're in now, she presents herself at the border, she's going to file the I-360. That's the form that documents the relationship and proves that she suffered extreme cruelty. That's going to get adjudicated by USCIS. Once that gets approved, she could request employment authorization. But put that issue aside for a moment. Once that's approved, she has a choice. She can ask the judge to remand the case back to USCIS, so get her out of removal, and then file the I-45, the change of status. Or she could file the I-45 and go forward with a trial in front of the judge. Now, she might request remand and the judge may deny it. Probably not in her circumstances. But again, this assumes that component, the I-360, gets approved. It's not automatic. It's not simple. Sometimes it takes a long time. And I really hope she has an attorney who's done it before. Because doing it without an attorney is not impossible. It's just difficult because there's no room for error. If you make a mistake and your case gets denied, you might get deported. You might not get a second shot. Whereas if she wasn't in removal, if she gets denied, she could just file again, or she could appeal it. Not that she can't appeal it when she's in removal, but again, there's less room for error. So I would almost suggest the case get remanded down, because then she's no longer in removal proceedings. If for whatever reason the officer denies it, well, they might put her into removal, but then she gets a second shot at it. And then she gets an agency that evaluates it and will give her a decision, essentially telling her, hey, here's why we think there's a problem here. Here's why we're denying your decision. And now you can fix that to the extent that it's fixable. So I'd much rather get it out of the courts. There's a backlog of almost 2 million cases in the immigration courts. The delays are catastrophic. The level of mistakes that I am seeing by judges and the court is, I've never seen it in any court in the country. Not federal court, not state court, not municipal court. It is the most dysfunctional system I have ever seen. So absolutely anything I can do to avoid the courts, I will. Because I can't predict their outcome. What they did yesterday, they might not do tomorrow. Even if they want to. I mean, we're seeing decisions by judges on motions we never filed. We're getting changes to court appearances without any notice. It's just complete chaos. You file a motion, you don't get a decision. You call the court, no one calls you back. You write a letter, no one responds. It's completely and totally broken. So to the extent we can avoid it, we do. And that's the major difference, is being in removal. And being in removal today with a dysfunctional court system means sometimes we have to have hard conversations with clients, and they're like, are you kidding me? You must be lying to me. No court would do that. Well, unfortunately, that is the problem, is we're having erratic decisions by sometimes erratic judges, not purposefully. I'm sure some of them are really doing their best that they can, but it is a broken system. I hope I answered your question.
Oh, absolutely. Absolutely. And that's real eye-opening when you think about how disorganized they are, and then maybe as a function of time, how laws were passed, it just caused this chaos, layers of chaos.
I mean, it's part of it, but really what you have is, so even before Trump was elected, immigration reform was necessary. Mm-hmm. We were seeing uptake of cases, and the courts were struggling. I mean, there was already a backlog of 500 to 700,000 cases for 300 judges. So the everything was taking longer. Then you bring someone like Trump into the system, who did his absolute best to break the system. He worked really hard at doing that. He made sure that every case was going to removal, that officers did not have discretion, judges couldn't terminate cases, judges couldn't delay cases, judges were punished for doing what they felt was right. So all of a sudden, you're having decisions that are erratic, that have to be appealed, and it's like putting oil on a fire. Mm-hmm. It just blows up. So we try to avoid it as best as we can.
Yeah, well, and it's good that you're insightful. You know how to treat the beast and how to tame it. So, okay, well, now we're going to contrast a little bit on Maria's husband. So if Maria's husband was abusive, but let's say he wasn't a U.S. citizen, is Vawa still an option? What if he was, and then what if he was a green card holder, or maybe he never set foot in the United States?
Well, if he was a lawful permanent Vawa, in order to qualify for Vawa, you need to have a qualifying relative, parent, spouse, or child, who's a U.S. citizen or lawful permanent resident, meaning a green card holder. Now, he wouldn't be a green card holder if he never stepped foot in the United States, because green card holder, lawful permanent resident means your permanent residency is in the U.S., not outside of the U.S. But let's, for purposes of conversation, let's assume he was a green card holder and he got a job outside the United States, and he asked for permission to live outside of the United States during that contract period and to not lose his green card. That's viable and that's doable, but it's not likely, only because we're talking about, they already have 2 kids. He's been out of the United States for many years. So it's not likely that he's a green card holder, but it is possible. And there is no real difference other than when she files for documented relationship, in this case, extreme cruelty, it's called Form I-360. She might have to wait for a visa to become available until she can file for the change of status, maybe. But here she would have to do that anyway because she's in removal. Now, that depends on the visa bulletin, which is managed through the Department of State. So it's possible she could file for both at the same time. It just depends on whether there's a visa available at the time. If spouse is a U.S. citizen, it's called an immediate relative, in part because there's a visa immediately available. So if not an immediate relative, green card holder, maybe there's a visa, maybe there's not. We have to look at that particular month and say, can we file? And it may be that you can't file both at the same time. But again, here, because she's in removal, she wouldn't be filing both at the same time anyway.
Okay. All right. So in that case, is asylum now an option?
You mean if her husband was a lawful permanent resident, would asylum be an option?
Yeah. To the previous question, let's say he wasn't a citizen, or he was just a green card holder, or he never set foot in the United States, would asylum now be an option?
Okay, so let's take a step back. She's coming to the United States for asylum or VAWA. VAWA is the better option because I can remove the court, right? So you asked me that before. I might not have done a good job at answering it, but let me answer the question for the moment. What's better, asylum or VAWA? VAWA is better because I can avoid a trial in front of the judge in some circumstances. Because of the chaos, I'd rather do that. Doesn't mean she doesn't have a good asylum case, but with a backlog of millions of cases, chances are she's going to be seen quicker and get her case decided faster if it's a VAWA and it's out of the court system. Now, if her spouse is not a U.S. citizen or not a lawful permanent resident, VAWA is not an option because she would need to have a parent or spouse that abused her who's a U.S. citizen, a lawful permanent resident, and we know she doesn't have that. Her children are 2 and 6 months, right? So they're not causing abuse. They're not causing extreme cruelty. And her parents, we know, are never been to the United States. So that's not an option. If her spouse is not a green card holder or U.S. citizen, she doesn't have VAWA as an option. Her only recourse is asylum. And that's like most of the asylum seekers that we're seeing. Almost none of them have VAWA as an option. They have asylum or special immigrant juvenile if they happen to be under 21. That's a subject for another day because today she doesn't qualify for special immigrant juvenile. She is an adult and she's married. So she's over 21 and she's married, so she clearly does not qualify for that. But VAWA is her best course. Again, we can avoid the courts. She has, if you recall, we explained in the first or second episode that she actually took photos of one of the worst abuse she ever got when she was tied up and her husband hit her with a mop, with a handle, bruising her, beating the heck out of her. Well, she took photos of that. So she can document the abuse. It's not just her word. And for a VAWA scenario, the title is actually battery or extreme cruelty. So by battery, I mean hit, and she can show it. So based on the facts that we know, if it's presented well, she will get approved. Her I-360 will be approved. And then if she has a halfway decent attorney and a somewhat okay judge, the judge will, once the I-360 is approved, she has nothing disqualifies her. There really is no reason for the judge to say, no, let me insist on a trial in front of me. almost all of them will today, under this administration and on the present rules, they will grant a motion to remand the case down to USCIS. So now she's no longer in removal, and USCIS is going to interview her to give her the green card. And because she has nothing that disqualifies her, and they've already approved that it's a legitimate relationship and she suffered extreme cruelty, unless she shows up at the interview and gives contradictory information, she will become a lawful permanent resident.
Okay. All right. Thank you very much for that. And then, so now we're focusing on the kids. So what are the options for her? Like Mario's with her. Her dad is a U.S. citizen. What's he possibly eligible for?
So both of her kids are U.S. citizens. They're citizens born abroad. Now, the problem here is if they're born in the United States, their birth certificate shows born in the United States, automatic citizenship. Since they're born of marriage, where in this case, father is a U.S. citizen, it's after 2000, and father lived in the United States for more than 5 years. We don't know that for a fact, but let's say that we do. Right? So he lived almost his entire life in the U.S., and he happens to speak Spanish. It's one of the reasons why he was given this job in Guatemala, working for a U.S. contract. Again, those are facts we don't know. Let's assume that it's true. But even if he doesn't speak Spanish, it doesn't really matter. It's irrelevant for this. It just goes to whether it's a legitimate relationship or not, but they have 2 kids, so chances are that's a good relationship. Or at least a legitimate relationship, maybe not with the abuse, maybe not good.
It's bona fide.
But the problem becomes, how do we prove it, right? So if they did what they should have done, father took the kids to the U.S. Embassy and registered them as his kids. And they would have gotten a certificate of a child born abroad, of a citizen born abroad, and they would have U.S. passports. That is what my father did when I was born in Chile. My father was an Israeli citizen. I was born in Chile, and he went to the Israeli embassy. I had the equivalent of an Israeli social security number and an Israeli passport. I was born an Israeli citizen, even though I was born outside the United States. So here it's the same thing. Now, let's assume that didn't happen. Okay, so now, do the children even have passports from anywhere? I don't know. How does she bring them into the United States without his permission? Well, that's a challenge, right? Here she's coming. Let's look at it from another way. Let's say he wasn't abusive. Let's say she just didn't want to be with him anymore. And now she takes the kids, kidnaps them outside the country and goes somewhere else. Well, that could be a crime. He could call the police. He could try to file, kidnapping charges. Whether that's successful or not is a different story. And those aren't the facts that we have here, but understand that that's a possibility. If tomorrow I decide I'm going to leave my spouse and take my kids with me and go to Chile or Israel, what's my wife going to do? Maybe she's not a citizen there. Maybe she doesn't speak the language there. On what basis do I have to do that? So again, that does become a problem in some circumstances. Here, to answer your question, the real problem is, well, can we document who the kids are? So let's say that Maria had a tourist visa to come to the United States, because maybe they traveled here to visit for the holidays, to meet his parents and his family so his family could meet her. So let's say they had that. So that means children were U.S. citizens, children had passports, she had her visa, so she was able to come to the United States. She wouldn't have to ask for asylum. She could just come and then file for VAWA. Then we would avoid this problem. If that didn't happen, she didn't have a visa, and the children didn't have a passport from anywhere, well, that's one of the reasons why she makes the long trek the way that she does and presents herself at the border. Now, she can file so in the US, it's Form N-600, citizen born abroad. We're asking for a certificate of citizenship. If she could prove the document, if she could prove that husband lived in the United States and husband was a U.S. citizen and father of the kids, meaning the birth certificate of the children shows that the U.S. citizen father is the father, she could just go and directly file for a passport in the U.S. without getting the certificate. But I'd rather go through USCIS. I'd rather file Form N-600 because there I get a decision and I can appeal it, or otherwise, if I have to deal with the Department of State, they're a nightmare. You think the immigration courts are bad? Department of State is almost as bad. I mean, we all heard of the Hillary Clinton email lawsuits that happened. Well, those were lawsuits against the Department of State. And some of them are still going on because they're so backed up on getting documents. So the challenge, proving the citizenship or relationship of the kids, is just what did they do when the children were born? If they have nothing, and I have clients they're here without birth certificates, without passports, and now they want to get married. Well, how do they get married if they can't prove that they are who they are? So it really does become a challenge, but where there's a will, there's a way.
So Vawa sounds like the best option for Maria and other immigrants who have been, physically and psychologically abused by their U.S. citizen spouse. And it sounds like the children of U.S. citizens born in other countries are U.S. citizens. That's really important to remember, I think. I imagine that you probably see a lot of that. So things are looking pretty good for Maria and her family. But what if immigration officials don't believe Maria was abused? I mean, well, if they say you already tried to claim asylum, now you're just making things up to stay in the U.S., what would she need to prove that she was abused? What would she need to go through to justify that claim?
Well, first of all, she can file an alternative. She's not limited to filing only one thing. That's number one. Secondly, she might not have known all of her options when she came to the border, right? I mean, she's fleeing for her life. That doesn't mean she understands U.S. immigration law, right? So she shouldn't be punished for that, number one. Number two, she claimed asylum. That doesn't mean that she filed for asylum. Right now, the requirements are she has to file an application within 1 year of her entry. Now, that is changing. And in the future, the regulations the Biden administration has proposed say if she gets credible fear interview, if she's found credible, that is considered her asylum application. And that's a big deal because then she met that requirement initially. The downside is she might not have had counsel at the time. So her presentation, she doesn't know what she doesn't know. She doesn't know how to present it. She doesn't know what they're asking for. So maybe she makes a mistake and says the wrong thing, and all of a sudden she's not found credible. So that's a possibility.
What if they don't buy it? What if they don't buy it and they conclude her claim is not valid? What's the recourse for? Will she be deported?
Yes. In short, yes. Now, she files for something. Asylum, VAWA, both of them. Right? Maybe she goes to trial on both of them. Maybe she's denied on both of them. Then that decision becomes final in 33 days if she doesn't appeal it. So she has a choice. She either accepts the judge's decision or she appeals the judge's decision. By the way, if she wins, the Department of Homeland Security could also appeal that decision. Right? So just because she's happy with the result doesn't mean the government's happy with the result. Now, if she files for, let's say she files an asylum application and a VAWA application, and the I-360 gets approved, and then she goes and asks the judge to terminate proceedings and remand it down to the USCIS, and they do so, right? So what happens to her asylum claim? Well, the judge may ask her to withdraw it. It's a possibility, with prejudice or without prejudice. But for purpose of conversation, she gets remanded back to USCIS, and then USCIS grants her her citizenship. I'm sorry, her green card. But what happens if they don't? So now she's withdrawn her asylum application, and her VAWA is denied. But in this example, it would likely be denied because she commits a crime, or there's something else that happens after the fact. Because we know I-360 was already approved. So we know she's documented that she was married to a U.S. citizen, that she's a good moral person, and that she suffered extreme cruelty. Now she's being interviewed by an asylum officer, I'm sorry, by a USCIS officer, not an asylum officer, and maybe she lied. Maybe there's inconsistencies in her story. Maybe she committed a subsequent crime, like shoplifting that we talked about before, and it might negatively impact her case. Or maybe she committed a crime while she was in Guatemala, subject to the abuse. Well, she'd have to prove that. She'd have to prove that the crime was as a result of the abuse, not something else. And now, again, if she's denied, she can appeal to the Board of Immigration Appeals. There will be a briefing schedule, maybe there's going to be oral argument, and then there's going to be a decision. That decision, again, becomes final only if it doesn't get appealed. And if it gets appealed, it goes to the circuit court. In New Jersey, we're in the Third Circuit, so it would go to the Third Circuit Court of Appeals. Then there's a decision there. That decision is final unless it gets appealed to the Supreme Court of the United States. And that's the final law of the land. Now, you can request to file an appeal to the Supreme Court. Doesn't mean the Supreme Court is going to accept it. And at any point, the Board of Immigration Appeals or the Third Circuit Court or the Supreme Court might say, hey, you know what? There was a problem at the trial level, and could remand the case back to the trial level to fix something. Maybe now we're 8 years later. The law changed. Maybe the facts changed. Maybe she was accused of a crime, and then the case was decided, and then she was ultimately not convicted of that crime. So, but the fact that she was charged a judge might have found that she wasn't a good moral person. Give you an example. I have a case right now where someone was accused of horrible sex abuse of a minor, right? But it was an accusation. At the end of the day, the case wasn't proven. He was placed on probation, and a year later, the charges would have been dismissed, but he's been detained by the federal government. He's not been able to complete the requirements of probation. So the government has tried to argue that he's not a good moral person because we don't know why he was put into probation, which is irrelevant. Or because he might not comply with the requirements of probation, and he could ultimately be convicted of the crime. But our position is the government can't have it both ways. Either release him and let him comply, let him at least try, or don't, but you can't punish him for not having done it when you haven't let him do it. So again, the law is constantly evolving and constantly changing, but that is one scenario that could impact Maria if she's accused of a crime while this is going on. Depending on the severity, even after she gets a green card, if she commits a serious enough crime, they could try to put her into removal and take away a green card. The only people that can commit crimes and not get deported are typically U.S. citizens.
It's really eye-opening every time we meet like this, and you really share a lot with us today. What I like about it too is that if I was somebody in that situation, and there's going to be people out there in this situation, they now know how it's going to play out. For the most part, they know what to expect. So now that we've talked about the options available to abused spouses, everyone's probably wondering about how to apply for VAWA, as if this is applicable for you. What's the process? How much does it cost? How long does it take? Well, I'm wondering that too. But we'll wait for next week's segment to find out. Next time, we'll answer all those questions and more. So be sure to leave any questions you have for us in the comments. We absolutely read those. And don't forget to like and subscribe for more content like this. Also, if you have an immigration problem that you or a family member needs help with, please tell us about us in the comment section, okay? We may feature your situation in future episodes and hopefully solve your immigration problems too. What we found is with our community, the immigrant community, we got to stick together and we've got to help each other out. We've got to know, hey, how do I get these questions answered from people who aren't in a conflict of interest role? So who knows? You might be the next person to hear Welcome to America.
Thank you.